This video is for informational purposes only and is not intended to be legal advice.
Hello there. I'm Joseph Lavelle, and I am the founder of Dynamic Legal Solutions, LLC, and also the principal attorney of Navigate Legal Services, LLC, located in Salem, Oregon, which primarily focuses on family law matters. This is an article I wrote called What a Divorce Can and Can't Do for You in Oregon. Most people know that a divorce legally ends a marriage, but what else does a divorce legally do for parents with a child? First off, we offer our sympathies if you are considering divorce. A divorce is a life-altering decision, and if you need emotional support, you should seek qualified professional assistance. These professionals are great at what they do and can help you through these tough times. We hope this article serves to help you in making informed choices about the legal outcomes of a divorce. Once you decide you are ready to start the divorce process, it begins with the filing of a divorce petition. The spouse who files the petition is called the petitioner in the divorce proceedings, and the other spouse is referred to as the respondent. Within the petition, the petitioner declares factual information about the family, such as when the parties married, the children of the marriage, and current and former addresses that the family has lived at. It also details what the petitioner wants the court to grant them legally in the divorce. These are known as requests for relief. So what is the relief the court can grant in a divorce? The major types of relief you can request in the petition include 1. Dissolving the marriage, as opposed to requesting a legal separation that keeps the marriage legally intact. There are a couple different ways to do a legal separation. I can write about those in a different article. 2. How custody of the children is awarded, such as one spouse receiving sole legal custody or the parties sharing joint legal custody. 3. How the children will spend time with each parent. This is known as a parenting time plan. 4. Who will pay child support and how much will that be? 5. Whether there should be a spousal support award and who will pay and receive it. 6. How property and debts are to be distributed. 7. Changing a former name back to a maiden name. And 8. Other requests such as court costs and fees. Our initiating forms package contains the petition you would file with the court to start your divorce, as well as the options needed to ask for all the requests for relief you seek. The initiating forms package has all the requests for relief just mentioned, as well as others that are not found in other do-it-yourself divorce forms like the Oregon Judicial Department's no-cost forms. Making your request for relief in the petition does not automatically mean they will be granted. The other spouse, the respondent, can file a response and either disagree or agree to both your factual declarations and legal requests for relief in the petition. If the other spouse does not file a timely response after being properly legally served the petition, you can file default and judgment forms to ask the court to grant your request for relief by signing a general judgment of dissolution of marriage. If the other spouse files a response, then the divorce will conclude by either agreement of none, some, or all of the requests for relief. The outstanding issues will ultimately be decided by the judge at a trial. So what happens with the request for relief from a trial to a signed judgment? As mentioned earlier, if the other spouse contests your request for relief and counterclaims with their own request for relief, then the issues will go before a judge to be decided at a trial. In order to persuade the judge to grant your request for relief, you need to gather evidence and procure witnesses to testify at trial in favor of your positions. For example, if one of the outstanding issues concerns the non-custodial parent's income for purposes of child support, and the non-custodial parent has worked odd jobs or under the table independent contract work, then you need receipts and pay stubs that the non-custodial parent has received, but you may also need to subpoena the person who has hired the non-custodial parent for those jobs to testify as to the work the non-custodial parent has done and the money he or she has earned. Our litigation forms package contains a request for discovery of documents form, which when served on the respondent, requires him or her to produce financial record documents such as wage receipts and pay stubs. It also contains a subpoena for hearing or trial form that summons a person, such as the contractor, to testify to relevant issues. Once your case concludes by either default, agreement, or trial, the general judgment of dissolution of marriage will contain the provisions for how the requests for relief are decided. To finalize your divorce, the general judgment of dissolution of marriage form within our default and judgment forms package has the entries and instructions for the relief you are awarded by the court. The divorce process can seem complicated when hearing it for the first time. At OregonDivorceForms.com, we've created step-by-step instructions and video tutorials that guide you through the divorce filing process so that you can file with confidence. We have a growing number of resources that can help you throughout your divorce. Be sure to check out the blogs, articles, and other resources available for free at OregonDivorceForms.com to aid and assist you through your case. That concludes the article, What a Divorce Can and Can't Do for You in Oregon. I hope you enjoyed the article and that it helped you understand the divorce process a little bit better.